Welcome to Health Policy, Organization, and Finance. This is your Week 12 video. Last week, we looked at smoking and discussed the outer extent of those state police powers. Week 12 looks at advanced decision-making. We look at some of those advanced decision-making tools like DNRs, advanced directives, post forms, healthcare's power of attorney, and guardianships. The cases this week are difficult, but they're very interesting and very important. They really show what happens when the state's police power runs up against that federal liberty interest that takes us all the way back to the Jacobson case. Remember where the Supreme Court said that there's a fundamental liberty interest? Well, in the cases this week, that fundamental liberty interest smashes headfirst into that police power, and we see what happens. So, as you probably recall, we spent the beginning of the course talking about broad healthcare policies, how healthcare is financed. We discussed Medicare, Medicaid, private insurance, marketplaces, the uninsured. We looked at types of care, including acute care, subacute care, long-term care policy. In the past few weeks, we talked about how healthcare decision-making plays a really big role in how healthcare policy works. This is the last week of our decision-making part of the course, and the last couple weeks, we will talk about healthcare organization. So what are the tools you'll see this week? Well, guardianship is a tool that when a probate court basically gives healthcare decision-making power to another individual. It's a judicial order. Power of attorneys for healthcare are something that attorneys usually draft up that say, I want this person to make decisions for me, either in my absence or if I cannot make healthcare decisions. Advanced directives are similar, but it's basically when you set out what you would like to happen under certain circumstances. POLST are physician's orders for life-sustaining treatment, and DNRs are do not resuscitate. Those are a little bit different because patients usually do those with their doctors, where they talk about their options and what would they like to happen under certain circumstances. So let's jump right into the cases. The first case is Cruzan. The second case is Vaco v. Quill. Nancy Cruzan was in an accident, and she's basically being kept alive through medical technology. There doesn't seem to be a question here that there's going to be recovery for Nancy. She can't make her own medical decisions. She's probably not going to recover. Her parents have been appointed guardian by a probate court, so now they make the decisions. Nancy's parents request to have the life-sustaining treatment removed. The state Supreme Court denies the request to have the treatment ended so that Nancy can pass away, saying that there was no clear and convincing evidence that Nancy would have wanted that. Now, the U.S. Supreme Court takes that case on to look at the liberty interest involved. They hold up Missouri's decision to not allow the parents to withdraw the treatment. But they also say something really important. The principle that a competent person has a constitutionally protected liberty interest in refusing unwanted medical treatment may be inferred from our prior decisions. So, what they're saying here is, competent people are constitutionally protected to refuse unwanted medical treatment. We might have inferred that from prior decisions, but many of us did not, and this was a big decision. So, you might be thinking that this is a state court case. Well, again, this was a state court case that went up to the federal Supreme Court because the federal Supreme Court said it involves that liberty issue that we talked about all the way back in Jacobson. Let's look at the Vaco case. So New York made it a crime to aid another person to commit or attempt to commit suicide. However, we know that patients can refuse life-saving medical treatment. So the question was, what's the difference? Well, Supreme Court, a couple years later, said everyone, regardless of physical condition, is entitled, if competent, to refuse unwanted, life-saving medical treatment. But no one is permitted to assist a suicide. So, the court made a really broad pronouncement in the Nancy Cruzan case, saying basically people can refuse treatment even if it would save their life. However, the limits to that include that no one is able to assist in the hastening of a suicide. Wait a minute, isn't this a state issue under the police power like we said? Well, just like in Cruzan, the Vaco case is looking at whether New York's prohibition on assisted suicide violates the Equal Protection Clause of the 14th Amendment. So in essence, they were saying, yes, New York can make laws about health. However, we're looking at if that New York state law violates our federal constitution. These cases are long, but they're really interesting, and they're meant to make you think about how police powers are limited. You don't need to memorize them or understand them completely. They're just meant to illustrate what we've been talking about, in that health policy can sometimes go too far. We want to make communities healthy, but what limits us in our ability to make healthcare policy? So this section finishes up healthcare decision making. I hope you've enjoyed this part of the course. Thanks for listening, and as always, feel free to reach out with questions, comments, or concerns. Have a great week 12.